Okay, good morning and welcome to Mo Knows featuring me, Monica Mo Justice. Me. All right. I'm a little bit pushed today because I took my laptop and I was writing some notes this morning, so it's on my laptop. So I had to bring my whole laptop stand in here so I could see it. Then I've got my work laptop. I gotta find a skin for my other one, but I don't have to log in until 10 this morning. So um the that's because I already worked a couple of hours out of my day. Let me do a sound check. Oh my god. What? Hold on a second. Let me do something else. Good morning. Thanks for coming over. All right, let me check the no, I don't think that's it. Hold on. I gotta check this thing. Let me check it now. Let me check the no, I don't think that's it. Hold on. I gotta check this thing. All right. Let me check it now. You're gonna hear it and repeat. Let me check the no, I don't think that's it. Hold on. I gotta check this thing. Let me check it now. You're gonna hear it and repeat. You're gonna hear it repeating itself. Um, but let me go to audio here and it says mic volume. All right. That is why. Let's see what we're doing here. Let me check that mic volume. Hold on a second. Let us go back now. Let's see what we're doing here. Let me check that mic volume. Hold on a second. Let us go back now. All right, I'm gonna stay at that one. So StreamYard's got its own setting. All right, I'm gonna stay at that one. All right, so I won't sound so loud. I'm very funny about sound because things bother me. Everything bothers me. This morning I'm bothered. So I put on my t-shirt. If my mouth doesn't say it, my face definitely will. And that's been a known thing for me. So I appreciate the conversations I had yesterday with folks after I appeared um, on a live stream and I was expressing, I'm going to start to sound like Monton, my truth, which is, a, a, it is, the way I see things in the YSL case is slightly different from the way um, the social media has portrayed this trial and how people have interpreted it, seeking justice for the men that are standing trial today, the 6 men on trial today, with the understanding that this is a 28, is it a 28-man indictment? A 28-man indictment. So at the end of the day, um, you got people who are, they are just pro. This case needs to get thrown out. We need to have a mistrial and we need to go for bond. Listen to what people are saying as they're saying the things that they're saying, right? Why can't you demand for a mistrial and these people go home, right? What happens to normal? What happens generally when a person is found, and this is not in the mistrial world, right? Alec Baldwin, good example. He recently had a mistrial. Nobody was calling for a mistrial and let them go on bonds. So you see how it has been conditioned in your head that there's something here that gets people are just saying, let them have a mistrial and let these men have a bond. If you get a mistrial, you should be able to go home. It should be the end of it should be an end of the saga. Like if you wanted something to end, this would come to an end. But everyone understands that there's more to it. So that's why they're just demanding for bond. There's something else still out there. All right. Yesterday, I was perplexed in the morning during my morning commute listening to the trial. And I was listening to the attorney for I was listening to the attorney for Little Rod make a plea to the court. Um, make a plea to the court that she was under the belief that they would be testimony in the morning from the two men that were involved in the incident, the two survivors from the incident with her client. So it should have been Bernard Mitchell and Rodney Utit, or however you pronounce that. Sorry. So in the testimony of the young lady, this would be BJ and Ray, who were the other occupants of the car. Good morning. Good morning, the other occupants of the car. So she was under the belief. And I was listening to her and said, and so I just want to go back to yesterday's footage, and this is not something that I normally do on my channel. So this is definitely a newbie for me. Anybody that knows me, I don't like playing. I don't like playing these people's stuff. But I want to focus on her argument yesterday. So I'm going to go to present. Oh, it's not. Hold on. I got to bring this into a Chrome. Oh, maybe I could do that. Hold on 1 minute. Because behind this, hold on. Behind this, what would I need to pull out also? I was just going to watch this. Oh, my live stream here. All right. Let me know how the sound sounds. But I'm assuming that when you use this program, it's going to sound great because it's coming from them. To share audio, share a tab screen instead. All right, hold on a second. I can't share the audio that way on this video. Boop. Okay. Let me go to, I got to do it I got to do it from Google. So hold on a second. Let me go to yesterday. Oh, I didn't realize they was going live this morning. Anyway, I'll catch up. History. I think this is yesterday. One day ago. No, it's not going to be one day ago, but I want that one too. So let me go over here and let me find the other one. From my playlist. Did I play it? No. Hang on 1 minute. So sorry. I have them in a different format. Atlanta news first. One day ago, and it's this yesterday, 7 days ago, 1 month ago. I don't know why this is always complicated here. 20 hours ago was this guy that. All right, this one. 2 days ago, 5 days ago, 1 day ago, 20 hours ago. Mm. Well, good thing I downloaded it. Hold up, let me just go to my download. This is very interesting. Since I downloaded it, they removed it. Hmm. Shadow banning. It wasn't Monday I wanted to see. I want to see yesterday. All right. All right. Ooh, go, Monica. Let me make sure. I think this is the one. Yeah, this is the one. All right. So, all right. And let me go back to my whatever this is. Here we go. All right. Let me go back to present. Share screen. Which one is it? It's this one. Also share audio. Yes, so share. So we should be able to hear this now. So I want to go to the very beginning of yesterday. Oh, this is gonna kill me.
Okay, this is just about scheduling. Well, it had been the understanding, I think, of the sheriff's office that y'all weren't going to use that witness at all. So, I mean, I don't know. Okay. Do y'all want to approach?
So this is how the day started out. So hold up. Let me see how that sounded. Because it sounds pretty low on my end. Oh, hold up. Let me do it again. Hold up. I gotta be on real time to hear it.
Well, it had been the understanding, I think, of the sheriff's office that y'all weren't going to use that witness at all. So, I mean, I don't know.
All right, so I hear it. All right, so they started off the beginning. They started off the day. All right, so they started off the day with bringing up the issue of Bernard Mitchell and Rodney Upton, if they would be present for and they wasn't. The judge explained that in the afternoon the day before, she was told that they were going back, and the defense attorney made an argument that this would be grounds for a mistrial because she couldn't the previous information that was presented by in DA HILES should not have been admitted. Let me make sure that's the DA. That they brought in the information through Hill, Hiles, and it shouldn't have came in through. He's the wrong, and she made that motion the day before that he was the wrong person presenting this information. I guess I'm gonna have to start to learn how to do video editing to really make my connect. So is this when they return? All right, let's see.
Isn't necessarily applicable anyway.
So, and my concern.
All right, I'm gonna come back to this one because that's the other issue of the day. But here comes this lady right here.
Objection that still needs to get hashed out.
Yes, Your Honor.
All right. Okay, and then if so, where's the easiest place for me to find the
Your Honor,
evidence?
if I may, there's something we wanted to address first.
Okay.
Your Honor, I've got some members of the defense side here taking a look. Our understanding, and if it turns out to be wrong, it turns out to be wrong, was that the state was undecided yesterday as to whether they were going to call Mr. Bernard Mitchell. I know at the lunch break, Mr. Hiles was on the stand. His text messages had already been admitted. We went back to speak with him. The state went back and attempted to speak with him. So at that point, my understanding was it was still up in the air. I can be wrong. My understanding was it was still up in the air. Per Your Honor's request, we had discussed as many things ahead of time as possible. The discussions with the state were, and it was very clear for both sides that we were not going to be objecting and not asking this court to litigate Mr. Mitchell's Instagram records because the state was going to call him. Yes, with them coming in, there were portions that we intended to use with the understanding that that is what would come out in terms of evidence. His messages would come out, so we would want another section in there. If the first section is in there, we would want the second section in there. But he's certainly not our witness. The evidence he presents is not a theory of the case that we would have brought to the table. And so now the state does not want to call him. And I think we're faced with a confrontation clause issue because we relied in good faith on our discussions with the state. We didn't go through and take the court's time to say this is conditionally admitted based.
Now you see what she's saying? She's saying we didn't take the time to go through and say this was conditionally admitted. So she's very well aware of the fact what she was supposed to do, but she was depending on the good faith of the prosecution. Here's the thing that bothers me with this case. People are screaming from the rafters that there is corruption coming out of the prosecution's office, right? So now you have a defendant. Why would you trust the prosecution if your position or the position at large is that they're not trustworthy? You can't say in one breath that, at least I don't believe that you can say in one breath that I don't trust you. You don't you like so this was making me angry as I was driving because I was saying you can't represent that I know what I should have did and I didn't do it. Basically, what she admitted to is that she fell into the trap of the DA, and that she would from now on litigate everything. Is how she ended it.
On this happening. So we simply relied on what they represented to us. We had the evidence, came in, it was read out. I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't.
Now, this is the thing that gets me. They feel they're in a position that they need to be forced to ask for a mistrial. This is what you hear coming from all these sides. Oh, we're forced to ask for a mistrial at this point. They goaded us into this mistrial and so on and so forth. This is very important to your client. Why are you not on your best performance at all times? Those are the things I don't understand. And those are the things I can't relate to, because I'm used to the people on the opposing side, the people that have to defend themselves against the state, against the government, are prepared and willing to fight the government by, with the process as it's outlined.
Want a mistrial. We'd like to be able to rely on what we were told. And like I said, we're checking to see if there's something.
I'm saying to myself, what trial she's been watching? We would like to rely on what we've been told. Since that Glanville days, I was wondering why these people do not file motions and put everything, memorialize their transactions in for the record, right?
Definitive on the record. But if Mr. Mitchell is not testifying, then we feel we have no option but to ask for a mistrial.
Okay, so now listen to how they pull out the ultimatums to the judge. We feel that we have no other recourse but to ask for a mistrial. Okay, now we're gonna. I think I want to pause here for a second, and I want to go to the day before, the night before. Good morning. I want to go to the night before and show you what happened the night before. And the reason why this one has me so upset is because Ryan's whole stature, right? His position in this case. Good morning. Good morning, Yvette. His position in this case and his posture in this case brings everybody down. He's the bad seed out of this whole trial. It's like when we watched Sesame Street growing up, which one of these people do not belong? They have the square box, and we got 6 square boxes here, and one of these people doesn't belong in this box, and he's the one that doesn't belong in this box. And he's the one that at this moment, in this phase of the trial, they are trying to write a limiting instruction to the jurors, which I will get to in a second. But I want to take us back a notch to what happened the day before. So I'm going to stop sharing this screen and go to my coverage from the day before that. Oh, where's the dates on this? Forget it. Hold up. I got it over here. So let me just. All right. So I know 5 is that one, and then 4 is going to be this one. I need the link to 4. Hold on a second. So this is the day before. And I want you to hear what she said to the court, or what happened the day before, which I think is extremely critical when you hear her making this complaint now. Hold on, I got so many screens to deal with. So first we're going to do that. Then we're going to do present, and we're going to share the screen, and we're going to share the screen of number 4. And we're going to go to share. And then we're going to go all the way down to the end of the day.
Ask the question.
All right, so this is the image of her cross-examining The man. No, what's the rest of his shirt say? Hold on a second. Let me just pause this. It says something about if you don't like what if my face doesn't tell it, hold up. If my mouth doesn't say it, my face definitely will. um okay, so she cross-examined the person, and I believe this is when the jurors are being excused for the end of the day. So I want y'all to hear the discussions that took place that evening. You know what? Actually, before I do that, I want to bring you to earlier. So today's Thursday. So this is Tuesday's video footage. And I want to go back to 3 hours. I want to go back in the day to 3 hours when they breaking for lunch.
Tenders.
All right. So this is when they're breaking for lunch. And this is what she's saying happened.
Where do you want these exhibits? Let me just
Leave them up there for right now. Thank you.
All right. I just forwarded through Ms. Persifield. I think you may have gotten a second attempt at a limiter, but I just sent to her and she'll send to you a third one. So use that one. And then I'd love for us to discuss that before we return with the jury. So you anticipate it'll be this witness, and then do you think we'll get to I guess Mitchell and Otten or Uten today?
Yes, Your Honor.
Do you think we'll?
So you see, they're talking about the two witnesses that Abasi would like to and have presented for the day. So listen to what they're saying.
Get past those two?
If we do, Your Honor, I believe we wouldn't get, I don't believe we would get past Detective Hogan,
Okay,
which would mean we would not need that instruction.
until tomorrow.
Correct, Your Honor.
Okay. Well, considering that some of the people have some other things to do, they're on the lunch break, why don't we just be back at 1:25, and then maybe in the morning or in the evening, this evening, we'll deal with the limiter. Okay. See y'all at 1:25.
All right. So before lunch, they thought they was going. Now let's go over here to 4 hours 56. So I did do my due diligence today.
All right. Is there anything we need to put on the record before we get the jury out?
Okay, now notice she's asking this question because we're going to learn the next day, which was yesterday, so this is on Tuesday. So Tuesday, after they come back from lunch, she says, there anything you want to put on the record? Now, if I was a conspiracy theorist, like some people would say, I would say this is the point when the judge knew that the two witnesses, Bernard Mitchell and Rodney Uten, weren't going to testify. And she asked if there was anything that they wanted to put on the record. This will be very important because she refers back in her responses on Wednesday. She refers back to this point in time and the information that she had available to her at this point in time. She did not do a full disclosure, like, hey, just like, I don't know what to expect because I'm not sure if you would have, if this is customary for a person, for the judge to provide you with the information that she's been provided with from the deputies. And the reason why that's important is that the information that she's relying on came from the deputies. And whenever she's communicating with the deputies, it is for safety concerns. So no, she's not going to announce that prisoners that came from inmates from yonder are on their way home because, or back to wherever they came from, because that's a security concern for the sheriff's office who is transporting them. But this was the time for them to put this out. So I just want to point it out because it comes up later on Wednesday.
One thing we're trying to figure out.
Okay, go ahead.
And by manipulating the guy that controls the recordings, so you don't know when they're going to the bench, all you seeing is the seal. It's very hard to triangulate on these issues that come up. All right, so this is the end of the day. This is the end of the day on Tuesday.
All right. I think tomorrow we'll have Detective Hogan and the ME, and then move on to whatever the next group of witnesses is going to be. Okay.
All right, pause. This is from my side of town. This is what we do. We do pause. You heard what the judge just said? She outlined who will be testifying the following day. So let me go back to my notes because what I heard was Detective Hogan, who is the old man who got the old detective who got on the stand, and the medical examiner. And then she said, after the medical examiner, she said, then we'll move on to other people, the next set of witnesses. Let me just rewind that for the people that love to listen like I do, that have sharp listening skills, to just hear what. So this is Tuesday evening going into Wednesday.
All right. I think tomorrow we'll have Detective Hogan and the ME, and then move on to whatever the next group of witnesses is going to be. Okay.
Next group of witnesses. Look at Abati or what Abati right here, and D Williams. Now I'm not gonna say that they don't look confused, But I'm going to say they did not zealously represent their client and his the interests of their client at this time. They look like they're out of their league. Let's watch them and the rest of the proceedings from that evening.
Who? One of
That we've
them-
already been discussing with Mr. Lee.
Now notice they're talking about Mr. Lee now, right? Which is the last witness or the witness that led to all the mistrial stuff. Now notice what is going to come out of Little Rod's attorney's concerns and interests at that moment.
Oh, right. Okay. Okay. All right.
So she says, we're going to find out if the state is calling the other people, right? So this is her saying that she indicated to them by pointing to the people in the room. Here's the thing, and it's unfortunate. Everything has to be part of the record. People keep saying, why are they reading this stuff into the why is they having the witness testify? Because only what the witnesses say gets documented in the record. So when they're presenting this evidence and it says stuff on it, right? And they present a picture and the picture has words and you have to have the person on the stand reading the words, that's introducing the picture into the record. Just having the picture alone is not the record. You have to give a description of it. Why do you think you hear them describing the defendants and what the defendants are wearing the day in the court and making it very specific? Because you want to be able to put in identifiers into the record. This is all building a record. So pointing to a door is not building a record. Moreover, failure to use your microphone, it's preventing anybody, especially a court reporter, from capturing all of the activities. And last but not least, we learned from Glanville that the court reporter, when you're talking over the judge is whatever the judge is saying is what the court reporter picks up first, because if you had a pecking order, this would be the order of who's important. The most important person in this discussion right here is what the judge says. So they immediately go to what the judge says opposed to what you're saying. That's why talking over people in court is highly not related, highly, what am I using the word for it? It's not what you're supposed to be doing. It's discouraged. That's what I'm going to say. Highly discouraged. Let's continue. So this is why it's not in the record. And then she's asking Kokomo, right? Kokomo is the paralegal for Stillwell. Now we're happy to see that all these people are working in concert with each other as defense attorneys, but not really. They all have the interests of their client at the foremost. So now she's dependent on Wednesday for Kokomo, but right now we're on Tuesday, so I'm gonna take it back. A smidgen. Ah, darn it. I didn't mean to take it back all that much.
All right. I think tomorrow we'll have Detective Hogan and the ME, and then move on to whatever the next group of witnesses is going to be. Okay. Who? One of
Now you see how they doing this who thing at the moment? Who lady? Who? Okay, so listen.
We've
Then-
already been discussing with Mr. Lee.
I was trying to find out if the state was going to be calling.
Oh, right. Okay. Okay. All right. Okay. Is there any other matter we need to take up this evening before we leave?
Not on behalf of the state, Your Honor, and I am still working on the other matter regarding the instruction and law. I have been working during this time with other members of our
Okay.
office.
So
You see their confusion? The two of them just sitting there amongst themselves. You got to be aggressive and stand up for your person.
you saw what I sent out through Miss Percival. Okay. So obviously we'll need to do that maybe at lunch tomorrow. As soon as y'all got something, you can send it. Somebody had, I don't know who it was, but a computer that was making noise a couple of times, like the dings, when you get, I don't know what, an email or something. So just try to, everybody, please make sure your computer is on silent, or the volume or the alerts or whatever are off, the notifications. Yes, Mr. Sharp. Mhm.
Notice he has an issue. He's walking up to the podium to express his issue. Generally, when people are speaking in court, they rise and they speak to the judge, right? So that they're acknowledged and everybody knows who's speaking. The court reporter is documenting what that person is saying, not pointing. Notice that we're going to hear from Short. Let's see if we ever hear from Little Rod's attorneys again.
I don't know. There we go. I don't know how many of my colleagues received this email, but I received an email from one of the prosecution team this afternoon, I believe, that has a bunch of folders for proposed exhibits involving the incidents alleged to involve Mr. Huey. I don't believe that we've, when we went through all the folders, I don't believe that we've litigated anything involving those. And I just wanted to bring it to your attention so you knew.
When are we getting to that?
I don't believe that we'll get to them tomorrow. These are items from Mr. Huey's phoned up.
Do you expect we're going to get to that this week or before we have our next non-jury day?
We can not get to it. In other words, we can put it off if we need to. I think at the earliest it would have been Friday, but it could have been next week.
So we're not scheduled to have another non-jury day until what, November? Not the 1st, the 8th. And I just hate to waste the jury time. So,
And I'll confirm with the other team members whether these are items that were previous.
I think this should be the first thing that they do when they send out a new dump. They send out a new link with a whole bunch of documents. So let me explain what that process looks like. Initially, you get a whole bunch of stuff from the prosecution, which is the whole case, right? Allegedly, because we see it didn't happen here. In your discovery package, you get everything. Then somewhere before the prosecution normally gets to this phase of trying the case, they send you a packet with what they specifically intend to use at trial. In this case, they ain't been doing it. So every time they go to now, they're about to have a witness take the stand, they then introduce out of what is supposed to be the discovery, the specific materials that they're going to use out of the discovery. I can't understand why someone hasn't told this prosecutorial team, whenever you send out your evidence of the materials you plan to use, direct them also to include in your messaging to them your original date of distribution. So what you would just say, on November 2022, this was in link blah 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 blah. We intend to use the following materials, and here they are for your for your perusal, right? So that means you're not sending new material to them. You're sending just something for them to look at, but they have previously received it. This level of communication would be so much more effective in this case.
All right, y'all figure it out. But obviously, if it's going to take, more than like a lunchtime or two, we're going to need to wait until there's an on-jury day to do it. And I know Mr. Matthews filed a motion limiting about one particular.
And this is how they are missing material that needs to be edited. Because when they get these dumps, they're waiting for this larger conversation, because you can't have an independent discussion with these people. So they're waiting for a larger conversation when they're all in a group to go through the material and say, hey, this one is not acceptable. Okay, we agree to this one. They want to have a sit down because they can't have one outside of the court because their relationships are not fruitful here. These people, the relationship in this prosecutorial team against the defendants is broken.
Piece of evidence, we can take that up at the same time.
That's correct, Judge. I
Okay.
did file a motion in limine. There's probably going to be a few more that's going to come in connection
Okay.
with that. So Mr. Shard is correct.
Okay, so notice how Mr. Shard is talking about a packet that he received that contains materials that are specific to Huey. Now, Huey's attorney is standing up and he's explaining to the judge that he's going to file some motion in limine. That means to restrict some of the material that's within there, but there's more to come on this.
That was a couple of days ago, that motion in limine. Okay. Well, I mean, y'all get together on it, do what you can, narrow it down, and keep me posted.
Now, do what you can, narrow it down, right? I'm sitting I'm amongst people that keep saying, do your homework. And I keep saying, this is an example of both sides of the fence needing to do their homework. Looking at the material that you have before you and outlining why you would not, why you don't want this material in, and what would be the reasons to allow this material in. So when you're sitting before the judge and you're going, well, item number 85, you're able to say, Your Honor, I reviewed item number 85 and I believe it should be excluded for this reason, right? We're not seeing that so readily happen here. We're seeing people sitting with the material for what appears to be the first time, and then they start to make, well, let me see this. And they don't have their arguments formulated ahead of time because they haven't reviewed the material. I believe and I contend that happens on both sides of the case, from the defendant as well as from the prosecutors. Okay, guess who's standing up right now? Now, do you think she's standing up to ask a question about Mitchell or Arnett or whatever his name is? Let's see what she's standing up here for.
Reminders in the morning, we'll need to take up the legally messages. I've not had a chance to review them today.
She has not had a chance to review the Lee stuff.
And how long do we think that's
The
going to
messages from Winnie Lee.
take? How long do you think we'll need for that?
I got about halfway through them and do have some objections. I'm gonna.
Are we going to have enough other witnesses to carry us to the lunch hour
Yes.
before we reach
Yes.
Winnie Lee?
Yes, yes.
Although
We can do that.
I really wish I would not take every one of my lunch hours. I was going to take one of my brethren for a birthday lunch.
So now, when this lady's up here smiling, we'll have other witnesses. I think she's under the belief that she's going to have Bernard Mitchell and Rodney, whoever his last name is, Onat, whatever. But she doesn't say it specifically on the record. She doesn't make it clear. She's not creating a clear record.
Lunch tomorrow, but I guess I won't be doing that.
Your Honor, we can also talk about that with Ms. Abbasi and her co-counsel this evening. If
It
that
would be
may-
wonderful if y'all could.
And what are they talking about this evening? They're talking about the Lee stuff, not about the other stuff. But any event, she's got one thing in her head that they're talking about, and they have moved on because the judge already came up here and told us that it's going to be a detective tomorrow. There is going to be a medical examiner, and then there's going to be Lee. Those are the three people that are coming to testify tomorrow. Only in her mind, right? In her memory, is she formulated that she's going to have Bernard Mitchell and Arnold or whatever on the stand.
Sort it out and come to agreement and give me, 1 or 5 minutes worth of things to decide. All right, y'all, please do whatever you can on that. And I guess I will see y'all at 8:45.
Your Honor,
Yes.
can I just also, I'll be filing and writing, there's a PowerPoint.
Notice how this guy just stands up and he's going to be. Hold up. Let me see what this says. Reba McEntire said it. Don't trust your soul to know backwoods Southern lawyer. So don't trust your soul to know backwoods Southern lawyer. Was that a lyric in a song? But notice how still it's making a record.
We were provided by the state. It deals with investigator Viverito. It's 41 slides. I've made a specific objection to the slides that I believe should not come in. There's
Did
law in
anything
there.
like that, Operation Planners
Yes,
PowerPoint?
it's
Okay, now before we get to the sarcasm in the judge's voice about is this anything like the Operation Planners PowerPoint? And he's like, yes. Please note that he is making a record. Good morning, cousin. How you doing? That's my cousin. Okay, he's making a record.
it's not as bad, but yes, it's there's law in there. OCGA. It's her opinions that Mr. Williams is a leader of a gang. Mr.
Okay,
Huey's an
well,
armed
get
robber.
together with somebody from the prosecution team to try to narrow that down to what is actually relevant and admissible, please.
And Your Honor, we're
I'll
gonna
put
be-
it in writing, and then this way they can. Mr. Body said he'll look at it.
All right,
Mr.
wonderful.
Hughes is going to be joining me,
Thank you.
Judge. Thank you.
And so we're just, our expectations are what they should be. I think we'll get to Mr. Williams.
Your expectation, Pee Wee Herman, is to grab the microphone and talk to it. Ooh.
Before lunchtime.
You do?
I want to make sure that's put in the ether so no one's caught off guard.
Oh gosh, I wish y'all would let me know these things before I would have said, jury, come back at 9:30 in the morning instead of 9. Maybe I can still get that message out to them.
We'll arrange it so we'll just go out of order. We'll do that.
Okay. All right, I'll see y'all at 8:45. Y'all try to sort out as much as you can before then. Thank you.
No, this is the end of that day. So now this is the end of Tuesday. So when she's making this argument on Wednesday, this is why I'm upset. Hold up, let me make sure I'm at the right video. Kristen, she's now I don't remember which one is which. Hold up, I gotta go send. All right, so which one is this? Hold up. They have numbers. It's not that it's a 3-ring circus. And again, you are welcome to have your opinions be different from mine, right? I'm not a cult leader here. I'm not trying to convince people to think my way or whatever. These are my opinions, and I'm entitled to my own opinions, but I'm not entitled to my own facts. And I cannot appreciate when people create their own facts to support their opinions when it doesn't align with what actually happened. It's not a real time. Um, uh, it's not equivocal. It doesn't equate to what happens in real time. Here we are now. We are in the morning, Wednesday morning, when she is explaining to the judge what happened the night before. So now we've all seen what happened the night before.
Would the state like to be heard on that?
I'm gonna
If
just
so, where's the easiest place for me to find the
Well,
evidence?
if I may, there's something we wanted to address first.
Okay.
Your Honor, I've got some members of the defense side here taking a look. Our understanding, and if it turns out to be wrong, it turns out to be wrong, was that the state was undecided yesterday as to whether they were going to call Mr. Bernard Mitchell. I know at the lunch break, Mr. Hiles was on the stand. His text messages had already been admitted. We went back to speak with him. The state went back and attempted to speak with him. So at that point, my understanding was it was still up in the air. I can be wrong. My understanding was it was still up in the air. Per Your Honor's request, we had discussed as many things ahead of time as possible. The discussions with the state were, and it was very clear for both sides that we were not going to be objecting and not asking this court to litigate Mr. Mitchell's Instagram records because the state was going to call him. Yes, with them coming in, there were portions that we intended to use with the understanding that that is what would come out in terms of evidence. His messages would come out, so we would want another section in there. If the first section is in there, we would want the second section in there. But he's certainly not our witness. The evidence he presents is not a theory of the case that we would have.
Okay, he's not their witness, but remind me to go back and show y'all a slick move that D. Williams did to Miss Smith on the stand when she had Miss Smith put letters on a picture, right, that she admitted into evidence. I'm sure it's the crime scene where she was hiding in the bushes, where Ryan came out. And then she never presented it after she had the girl make the marks on it. She never presented it as evidence. That's her sneaking that paper in for another day. Sneaking that paper in for another day. When the lights went out in Georgia. Georgia is interesting, but let me not interrupt her while she's telling the judge about this new mistrial motion that she woke up in the morning, yesterday morning, and wanted to put out here in the, what are they calling it? In the ether.
Brought to the table. And so now the state does not want to call him. And I think we're faced with a confrontation clause issue because we relied in good faith on our discussions with the state. We didn't go through and take the court's time to say this is conditionally admitted based on this happening. So we simply relied on what they represented to us. We had the evidence, came in, it was read out. I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial. We'd like to be able to rely on what we were told. And like I said, we're checking to see if there was something definitive on the record. But if Mr. Mitchell is not testifying, then we feel we have no option but to ask for a mistrial.
Now, I am not a lawyer, and I think she did a great job yesterday telling us about the atmosphere and the climate inside the courtroom. And I really appreciated hearing her accounts of it. I would have loved to have heard Sylvia's accounts of it, but I'm no longer a member over there. I only did a 1-month membership. And I did a 1-month membership because she got demonetized. So I felt as if forget it. Anyway, because maybe I didn't. I might have got a free membership over there. I think I got a free membership over there. I've tried to support the platforms that are out here covering this just to give back. But it's not necessarily a requirement of mine. This just I just was so angry yesterday when I heard this, and then even having heard the information against Little Rod in its entire, well, as much as we got yesterday, I really didn't feel like they had pinpointed that he was the actual that it was his direct action that resulted in the untimely death of someone.
Would the state like to be heard on that?
I guess the state's response, Your Honor, is that the state, after the lunch hour, indicated to.
Talk into the mic. Pick one up, maybe.
Now, I want you to know that the judge then is when after she hears from the state, she starts to provide them with her account. And remember, we already saw what she said on the day before when they returned from lunch, when she only asked anybody if they wanted to put something on the record. And that's going to be a thing. Now, forgive me. I'm a troublemaker in my office. If somebody comes in and says to us, anybody got any questions? First thing come out of Mo's mouth is, what you want us to question you about? What you thinking? What you talking about, Willis? That's how I be acting inside the office. But this is just it.
The state, after the lunch hour, indicated to the court, as well as
the judge in this instance, to me, based on going back and knowing what she knows at the time that she's having this argument with her, and then watching her actions later on in the day, which we're going to get to also as it relates to this issue, I think she understands that she's complicit. And I want you to hear my words for what she's complicit in their defects as being prosecutors. And maybe it's the complicity that the community at large, the social community at large is upset about. Because remember, this is Georgia, and there's a community that lives around this stuff, and they're not protesting. They're not out there angry about it. They can't even organize a protest in respect to this, and they live right there. That speaks volumes about what is going on versus what you see in social media with a handful of people and what you see in a community with people that are on the ground. So let's hear what the response of the prosecution, the state, and then let's hear what the judge has to say.
Counsel, at least for Mr. Ryan, indicating that we were not going to call Mr. Mitchell, basically because he told not only the state but defense counsel that he wasn't going to say.
Notice Kokomo is over here showing her what he got back from the feed from the night before.
Anything when he came onto the stand. That was the same thing that was told to us by Mr. Uten. And my recollection is that it was an either or is what the understanding was. It was we were going to maybe call either Mr. Uten or Mr. Mitchell. And yesterday we decided neither. So I don't know how there could be a confrontation issue that's being claimed today. If we decided to put Mr. Uten up yesterday and not Mr. Mitchell, the records would have still come in the same fashion without Mr. Mitchell testifying. More importantly, before any message came in as it related to Mr. Mitchell, the state indicated to defense counsel that we were not calling Mr. Mitchell. We indicated that to the court as well.
I don't remember y'all indicating anything to the court until the end of the day. Y'all,
Notice the court right now is trying to clean up her record. Like, she's not going to be a co-conspirator in their stuff. So she starts to clean up her record.
but what I was told by the deputies was that the state had very clearly said they can be transported back. We are not calling either of them. And that was right after the lunch hour that I was told that. I asked yesterday morning, is this an either or? And yesterday morning, the state was definitely indicated, it might be one, it might be the other, it might be both. We don't know yet. We still need to talk with everybody. And then we just went on with the trial, and they didn't, after lunch, they went back because y'all had made that determination, and you certainly communicated that to the deputies with regard to transport. And you are making the representation that you also let the defense know that. Do y'all disagree that the state let y'all know they didn't intend to call?
Now, this is where I completely lost it. But let's hear what she has to say, and I ain't going to interrupt it because I already heard it.
Either witness?
Excuse me. At the very end of the day, I had inquired to the court, said, discuss what's going to be the order tomorrow. And I said, well, Mr. Mitchell, Mr. Uten, checking, Mr. Kokomo took a look, and before lunch, what was represented to the court said, who are we going to get to? And they said, we may not get to him today. So
that was before lunch.
That was before lunch, and then we came back in, and everything was published.
And everybody not everybody, but counsel for Mr. Ryan and counsel for the state spoke with, I guess, Uten and Mitchell over the lunch break.
We went back. He didn't want.
Notice how the judge is making her record. She's asking the questions, and it's all getting on the record.
Want to speak with us? That's fine. We went separately from the state.
Right.
We didn't discuss anything with the state about who would or wouldn't be called at the lunch. And I don't believe before we started in the afternoon. That's not my memory. The announcement before lunch was
That's not her memory.
May not reach him today. They spoke with him. Obviously, at the end of the day, I still thought they would be called.
My recollection is after lunch, I was sitting there. Ms. Abbasi said, so you're not calling Mitchell? And I said, no, we are not calling Mitchell. That's my recollection before Mr. Howes began testifying after lunch. And we didn't call Mitchell. And the messages came in unobjected or not objected to. And there's been.
Now, see, this is her problem. She should have been objecting, and she knows she should have been objecting. Why she should have been objecting? Just out of protocol to make a record. Period. Carenta, we'll get to the judge, and we'll get to the judge when I come back, because I gotta leave for a meeting at 10 o'clock. But and it's probably gonna be 10:05 because I'm gonna be running late. I'm gonna get to the judge as a separate part when I hear what shenanigans she comes up with today.
No conditional admittance of evidence that's been
There
permitted
has not.
or agreed to by any of the parties during the trial of this case, at least the time that I've been here. So it's my indicator, be the state's opinion that any objection to the messages that came in are waived at this point.
Your Honor, our response is, we have difference of memory. That's fine. It is what it is. If the state knows they're not going to call him going into it, I don't think it's fundamentally fair for them to publish and then say, ha, you missed it.
Ha, you missed it.
I don't think that's good faith. As far as, no, we didn't conditionally admit it, because we've done everything we can, at least for Mr. Ryan, to avoid taking up the court's time. This is what it was. We all agreed. We all understood. So that's how we proceeded. And now here we are, and we're stuck in a position we don't want to be in.
Well, I'm not quite sure what to do with this. I have a representation from Mr. Abadi that the state communicated to defense counsel that they were not.
See, I'm upset. The dog knows it. He's barking at me. Whenever I get upset, he barks at me.
Intending to call Mr. Mitchell or Mr. Uten, and that was communicated prior to Mr. Hiles' afternoon testimony in which this evidence came in. And Ms. Abbasi, you're saying, well, that it's not my recollection, but I could be wrong. That might be. So
I will not say my memory is perfect. I have no memory of having that conversation after lunch. I'm not going to say, you know, Mr. Abadi's. I can't promise you my memory is 100% accurate. And I'm certainly not getting up and saying that Mr. Abadi's lying.
The reason why she can't say that is because she knows that she didn't do everything that she could have done to make the record clear enough. This is when you have an out of body moment and you realize that you could have did more and didn't.
Not going to do that. But I have no memory of that conversation at all. And, you know, as I said, I brought up at the end of the day, you know, what's the order of the witnesses? When are Mr. Mitchell and Mr. Uten coming in?
No, you didn't. And we went back and we watched it. That's not what you said. And they were clear who was coming up.
I don't remember that.
I had brought it up when we were asking about witnesses because I didn't know if the sheriff needed to bring them over. And that's what was coming up.
Are you saying that you on the record asked when Mitchell and no, you didn't?
That was at the very end of the day. We were just
Amongst counsel?
I believe Your Honor was on the bench when we were discussing just who are we getting to tomorrow.
Yeah, I asked who we were getting to tomorrow. I don't recall you saying when are we getting to Mitchell and Uten.
Well,
I don't recall the two of them being mentioned at all at the end of the day.
I know I asked the state at that point, oh, you're not calling him? No. And at that point, the evidence had already been admitted.
I'm asking you, did you make that statement on the record?
I don't believe so.
I
We can
don't
check the
either.
record, but I don't think so. I think the last statement on the record was we may not get to them today.
Do you see why this guy got life?
I don't recall that statement on the record or off the record. This is all a surprise to me this morning that now there's some debate about it because everything I knew post lunch yesterday, although through the sheriff's office, not through the state or the defense, was that a decision had been made and communicated that neither of them was going to be called. I mean, can't really do much else with I don't see a basis for a mistrial. So we need to deal with Wooney Lee's evidence. And y'all are just going to have to communicate or put more things on the record or something if you want to avoid misunderstandings in the future.
That's fine. We'll litigate everything first.
All right, that's fine. They'll litigate everything. When I heard that, my initial thoughts, and they ain't changed today, is that she knew going in that it was a lose-lose situation. And she just wanted to make that mistrial motion, no motion. Notice she did not reserve the right before the next question, which is something that we learned from Steele and them as they argue every motion.
Or just put on the record your understanding.
Yes, Your Honor.
So if the understanding was these will come in if Mitchell testifies, just say, we talked about all of this and we don't have any issue as to, X, Y, and Z. And these things we've agreed are going to come in if Mitchell testifies. And then there'll be a record of it and everybody will know what they're dealing with.
I mean, I guess the state can make a suggestion. I mean, we can call him and the state will have no questions for him and then defense counsel can cross him if that will solve the issue.
I mean, at this point, he might have yet again been sent back, even though my staff was making Herculean efforts this morning to try to get him over because somebody wanted him. At the bench, y'all said, nope, that's fine. We don't need him. And by y'all, I mean, you, Miss Abbasi, said, that's fine. We don't need him. If y'all aren't calling him, fine. So we just communicated to the sheriff's office. They don't need him. I don't know where he is at this point.
Okay. So these are the moments when I think the shifts change. She just submitted. This is the judge. So we had 38-18. I'm going to go back to 37-59. So you can hear what the judge said that they did. So it sounds like to me when the sheriff came to her on Tuesday at lunchtime and said that the that he was being released. It sounds like this is what the judge's response was.
Y'all said, nope, that's fine. We don't need him. And by y'all, I mean you, Miss Abbasi, said, that's fine. We don't need him. If y'all aren't calling him, fine. So we just communicated to the sheriff's office. They don't need him. I don't know where he is at this point.
And Your Honor, Mr. Kokomo checked at the end of the day. I did inquire for the court, who do we need tomorrow? And gestured over to the door. And then that's when Ms. Love said, we've talked about it and we're not calling.
All right, well then, that's even more of a record against your recollection.
Do you see how crazy that sounded at that moment? That really sounds crazy.
I guess I don't understand. There would not have been any reason for me to ask about whether people were coming from the back after the evidence had already come in if I knew he was appointed to be testifying.
So you're saying you pointed towards the holding cell doors.
Right, asking about witnesses for tomorrow.
All right, well, that is no record upon which to grant a mistrial. So let's get to the Wooney Lee evidence.
All right, now I want to go back. Same day, right before all of this happened, we got a motion from Steelcross. Lord, forgive me. A motion from Brian Steele. But you know what? My spirit guards are with me. Please, please don't let me go get the sage.
Okay. The trial. So I'm not going to get into here's how you're going to consider all of these different parts of the RICO count, you know.
I do understand, but as a listener, I guess, for a juror.
This to me is the most damaging thing that or exchange that I heard between the judge and Steele, which gave me the opinion that there's a lot of people who like Steele. So this is not a competition. This is not to be competitive because we have the life of liberty. We have the liberty of others at question. But what this shows me right here is everyone's position and trying to how important a record has become over what they're supposed to be there to do.
They don't even get
Give me
to
5 minutes.
decide the acts unless they first find it. They could do it any order they want, I guess, but they first find that there was a willful and knowing joinder of the conspiracy.
Sure, that's a part of what
Sorry, had to do something with my daughter. Hold on.
But they're going to have to find as to each defendant before they can convict anybody.
And I'd like that language in any instruction because otherwise, let's assume that this trial ends, the state rests in December. That's approximately a month and a half, maybe 2 months from right now. Meanwhile, the jurors are being conditioned, in my words, from the sound.
And actually, they already got through the first 49 witnesses on the state's witness list, which was supposed to have only 90-something people when we started. So they're looking good in terms of where they are at with their witness head count.
Court's instruction that, hey, yeah, we can use evidence against everybody except certain evidence. So I'm going to realize that this is against everybody before there's been no instruction to my knowledge in this entire case that they have to first find that there's a conspiracy, that a person joined the conspiracy.
They're not supposed to be deliberating until the end of this case, the close of all the evidence, all of the jury instructions. So,
and that is a fact. Jurors are not supposed to be deliberating. So, and this goes on.
there isn't a danger of that.
Okay, well, that's my problem.
All right.
Because
Well, I'm not going to give them a full kind of mid-trial mini instruction on how to consider RICO. They're not
Okay.
supposed to be doing that yet.
Okay, I'm not trying to say a full instruction, but just a line, maybe. I put it in
I mean, I
our,
can say, I'll give you further instructions later
on, I would,
on how to consider all of this.
and whether a conspiracy even exists, or a person joined a conspiracy. That's what I'd like, because I do find, and yes, I understand that they'll be instructed later, but I do find that it is, jurors should have some context of this instruction. This instruction standing alone seems like it's already, that there's a suggestion. I'm not saying the court's doing it on purpose, by the way, but there's a suggestion that other evidence can be used against everybody. Well, that may not be true.
I'm only saying it as to if the state presents evidence aside from the guilty plea as to overt acts 56 through 59, and then aside from Mr. Ryan's trial conviction as to overt acts 79 through 81, which, I mean, they're certainly doing that for the murder of Jamari Holmes. They're doing it right now. So if I guess I don't believe that it is broader than what this is saying, which is specifically as to those enumerated overt acts.
Now, I would like something, if you, ladies and gentlemen, find, based on my instructions that will come at the end of the case or at an appropriate time, that one or more of the people on trial knowingly and willfully joined a conspiracy, and then go into something about, then you may not use the guilty plea or verdict, whichever.
All right, well, I
against anyone
appreciate
else.
that, but I don't think that's necessary,
Okay.
and I don't think that this misleads them into thinking anything at all
Okay.
wrong with it. Okay,
And
so,
I still believe my original, that the evidence shouldn't come in at all, because I'm struggling with the instruction. So,
all right, well, I
with that
think
being said.
in terms of if anybody would prefer the language, you may not use this conviction in your consideration or deliberations against any of the other defendants in this case. It is not evidence of anything against these other 5 defendants. Each defendant has a right to have his guilt or innocence determined by the evidence presented against him, not by what happened with regard to a criminal prosecution against someone else. That's one version. The alternate version is you are not to consider the co-defendant's, whatever it is, conviction as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of, charges or something. I don't know what that language is, but any preference as to which of those two the court uses? No, nobody cares. Okay.
See, this is an example. It's not, this would be frustrating to me if you know that we're sitting here trying to draft out something and there's no equal participation from the parties involved.
Well,
either one.
I'm definitely going to give one or the other of them, because if I don't give one or the other of those, then it will be reversible error in the event that there ever is a conviction in this case, which of course would be ultimately a benefit to your clients to.
Okay, this is the argument that I think set mistrial in place, because there are key things that were said here that would make attorneys shiver.
Build in reversible error, but I would prefer not to do that, because the court's job, to the extent I can, is to avoid any error at all, much less reversible error. So I'm going to give one or the other versions of that language. Does anybody have a preference as to which version of that language the court will give?
Your Honor, can we, since I have a preference, I'm still maintaining my objection. I don't think it's reversible error if you keep out these pieces of evidence, and that would be my preference.
No, I don't think so either, but that's also not fair to the other side.
Can we just huddle for a minute so we may have
And
a
y'all
split?
don't have to tell me right this instant. I just need to know before the conviction is going to get introduced, which may be sometime today. Okay.
Now, this is why I'm ending here, but this is another reason why the style of Hilton has me disenchanted.
And if they're huddling now, once they're finished huddling, we just have another announcement to the court.
All right.
They're huddling now. We just have another announcement to the courthouse. They're huddling on a discussion or on a limiting instruction that you two should be helping to draft. So these are the things that have me frustrated with listening to these folks. I'll come back later in the day after we go through mistrial 10 or 501 and see what happens inside the courthouse. This is Mo. Today's broadcast was brought to you by the M and the O. I want to thank those of you who braved the the bleachers and came inside, or got out of the lounge and came inside the chat to adorn me with your comments and your support. It's truly appreciated. And I realize that I have a differing opinion because I don't stand with the norm. But these are just my opinions. You can do with them, or you can consider them for your own, for your, as information that you explore as you're looking at these cases and try to figure out how you navigate through it. Use your own, get everybody's voice out of your head and use your own personal experiences and your own knowledge to really navigate this process. It's not difficult. Legal minds is not that complicated, as you can see, but people are making it out to be more than what it should be, at a time that's critical to some other people, more so than us. Anyway, I'll see you guys on the back end.